Hey, 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 it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. Thank you for joining me today. This is going to be a Diddy update. Just kind of seeing exactly where his cases are and talk a little bit about Tyrone Blackburn, who is the attorney that is representing the plaintiffs in some of these cases. I'm not sure if you guys heard, but this past week, there has been talk about him being submitted pretty much to counsel regarding, well, to the grievance committee based off of the what they're calling frivolous filings and his colorful language and pretty much his way of including everybody and their mama in these lawsuits. And so I am just going to kind of go down the docket and read some of the back and forth exchanges on some of the cases that has been filed with Tyrone Blackburn as the actual attorney for plaintiff. It has also been said, and I want to say allegedly because there hasn't been any confirmation, but uh, there's a prominent law firm that actually dropped Diddy. I believe it's a New York based firm, Grubman, Shire, Marcellus, and Sack. Uh, from my gathering, is that Lady Gaga also has them retained, and it is alleged that she went to the attorneys. Then this is an inside source and saying, hey, if you are going to represent this person who is involved in these particular allegations, then I can be associated with you guys, so it's either him or me. And what you think happened? Bye, Diddy. I'm not going to, you know, lose out on something. So there's a lot of speculations out there. Now, I've been searching. Um, it hasn't been confirmed that she said that. So, who knows? It could have been a decision within the firm that they say, hey, it's too much heat, let's drop them. So it could be a number of scenarios and reasons as to why they dropped Diddy, but, we will never know. I don't think that is something that they are going to come out and say, hey, we dropped Diddy for this reason. But in the event that is true, whatever cases that he is on and he needs representation, in my personal opinion, I don't think that is going to be a problem with him finding counsel, because trust me, the first thing is money. Okay. So if you're going to pay me money to work on your case, I'm going to accept that and I'm going to do my due diligence on your case. So I don't think that he's going to have a hard time. Now, some of the more prominent firms, I know that you have, there's one lawyer, I forgot what his name, that represents 50 Cent and Eminem. I'm pretty sure that Diddy's not going to go to them and say, hey, can you represent me? It's not a conflict of interest. It's just more of, I'm trying to please my clients because I've been with them for a while and I don't want to break that bond or relationship or that rapport with them. So it's just going to be interesting to see how this is going to play out in the next couple of weeks. But without further ado, I do want to kind of go over some things. Let's see. Well, first and foremost, To kind of sum up how many cases this man actually has, it is over, let's see. And I've gone over them time and time again, but I still want to give you guys a timeline as to when these cases were filed. So, with Casey Ventura, it was November 16th, 2023. Joy Dickinson Neal also filed 11/20, well, not also, but she filed on November 23rd, 2023. Lisa Gardner also filed on November 23rd, 2023. Those two cases, Joy Dickerson Neal and Lisa Garza, were initially filed in the Supreme Court of New York under the Adult Survivors Act, and I'm actually going to put out a mini series that are going to be in parts of all of the celebrities who have been sued under this particular act. So stay tuned. It's going to be very interesting, and we're going to be reading some of the complaints and things of that nature to see exactly what these high profile people have been doing behind the scenes. Let's see. Now with Lisa Gardner, Mr. Blackburn, Mr. Blackburn, Mr. Blackburn. So, as you guys can see here, and I pulled up all of the cases that Blackburn is actually on. As you can see, you have April Lampros here that was filed on May 23rd, 2024. I haven't gotten to her yet, but hers was not filed under that Adult Survivors Act only because it ended on November 23rd, 2024. So I'll definitely kind of we'll go over that case docket and I'll tell you why what's going on and the reason why it's going on. But here, here's Lisa Gardner. Now, her particular case was actually deposed and it was transferred to the New Jersey Superior Court. What they pretty much argued in the Supreme Court was that subject matter jurisdiction. They pretty much said that because the actions did not actually happen in New York, there was no reason why Tyrone should have filed in New York. So they came to an agreement to dismiss the case, and well, discontinue, dismiss, however you want to say it. And Tyrone was able to file in New Jersey. With that particular case with Lisa Garza, now let me back up. So for Joy, we're just gonna kind of go and let's see. I'm actually going to look it up by because I don't think that he is representing Joy Dickerson. Okay, so here's Joy's case. Um, Yes. So Joy does not have Tyrone as the attorney. It is a different law firm that is that's uh is representing her. Here is Sean Combs attorneys on here. Jonathan D. Davis PC. And oh, that's another thing. So on this particular case, um and I'll show you guys in a minute, but pay attention to Sure Tremonte LLP. So those are the attorney of records as of May 30th. Okay. Now there's quite a things that have been happening on this particular case, but the main thing is that they are trying to dismiss these cases because they're saying um, the act happened so many years ago and it's not really covered under the Adult Survivors Act, so on and so forth. So they are literally going back and forth, and that is the main issue right now. So what we are seeing is just a lot of back and forth with, okay, I'm going to file a motion to dismiss. They got to hear the motion to dismiss. They have to argue, why are we dismissing this case? And then they'll say, well, the plaintiff failed to state a claim, and so on and so forth, or provide any plausible supporting evidence regarding the actual allegation that is stated in this complaint. So it's a lot of back and forth. But as any good defense attorney would do, is look for loopholes in order to dismiss a case in its entirety. And so let's see, an amended complaint was actually filed. Let's see, on May 17th. So, whatever they were trying to dismiss prior to that, as far as saying, okay, they failed to state this claim, what they do is they amend the petition and state the claim that they missed. But now, as you can see, they filed the amended complaint, but now they're trying to say, okay, we need to go ahead and still dismiss it because such and such. So it's a lot of back and forth. So you never really are going to get into the meat and potatoes, because their goal as a defense counsel is trying to get rid of the case, which is wild. All right. Let's see. So for that, like I said, that's Joy Dickerson, Miss Lisa Gardner, and I'm gonna show you guys that case as well. Let me go back. This is that. So Tyrone was the attorney. I said was, is the attorney currently representing her. Um, it does not show that Sean or Aaron Hall actually have attorneys, only because an answer was never filed. So that's why usually if an answer is filed or notice of appearance is filed, then this will update. So as of right now, Sean Combs and Aaron Hall does not have an attorney on record. But and I say but only because this case was actually deposed, because they discontinued this. So there was a lot of action and activity that was going on this case. Now let's see. Let me see. And it's so funny. I'm just gonna pull up and read some of this, because Tyrone, how can I say this? He's not, I call them baby attorneys. If you don't have a lot of years of experience, you're considered a baby attorney. I don't know exactly when he passed the bar and received his license, but the way that he's doing things, I mean, I get it, but people are saying, and when I say people, attorneys in the legal world are saying that he is just really trying to get recognized. And by him using all of this colorful language in his complaints and filing in federal, like, you're filing in these top courts. You're not filing in the state court. You're filing in federal courts. And they believe that he's doing this in order to get recognized. And I would get it. I mean, if you're trying to build up your portfolio and stuff like that, but just don't be filing frivolous complaints and pleadings and things of that nature, and stuff is not true, or you suing everybody and they mama, and you haven't done your due diligence to see how they are connected. Um, that's the biggest thing. So a lot of attorneys is reporting this man to the grievance committee. So I'm going to keep up with that and update you guys with what's being said. But I just want you guys to I want you to pay attention to how this man is defending himself. Let me see. I want to go in order, and we're not going to be here all day. Let's see. Yeah, so so the reason, this is the reason why this case was discontinued in the Supreme Court and filed in a New Jersey Superior Court. They stated that it lacks jurisdiction, and that, let's see, the plaintiff failed to state a claim against Universal Music Group. They failed to state just all of these things, which is a definite, because if you do fail to state certain claims or you file in the wrong jurisdiction, that is grounds for getting your case dismissed. So Tyrone is really treading very lightly. He's like on a fine line. Like, dude, if you go over one more inch, you're going to fall off. So you got to be careful, because you're putting the plaintiff's cases in jeopardy. And it's wild. But hey, that's Tyrone. Let me see. Okay, I'm gonna read the letter from uh who is this? Tyrone. Tyrone to the court. And it's funny. It's very interesting. So our office is counsel to plaintiff Liza Gardner, plaintiff in the above reference matter. I write this letter in support of plaintiff cross motion for discontinuance. Mind you guys, they're trying to kick it out of this court because it doesn't belong there. On or about 1990, 16-year-old plaintiff was provided alcohol by defendant UMG, was transported from New York to New Jersey in a car service provided by her defendant UMG, and was brutally raped by defendants Aaron Hall and Sean Combs. Aaron Hall was an employee of defendant UMG at the time. I understand why they included Universal Music Group, because it's just like, okay, like if we were working at a place and we done something wrong, eh, we represent that employer. So I get it. I get it. But he used very vivid language coming out the park. The UMG defendants are desperate to escape the dirty deeds of their past and, in many respects, the dirty deeds they currently practice. In 1990, they held an event at the subsidiary MCA Records where a 16-year-old plaintiff and her 15-year-old friend, Monica Case, were present. Why is a 15 and 16-year-old present at this type of event? Hmm. The defendants provided alcohol to these children and allowed them to be preyed upon by the adult employees, Aaron Hall and Sean Combs. The plaintiff was a child in 1990. She was not old enough to vote, to sign for a loan, or to drink. Yet the UMG defendants plowed her with alcohol and fed her to the pedophile employee, Aaron Hall, who they knew or should have known was a predator. 4 years after raping 16-year-old plaintiff, Aaron Hall impregnated another 16-year-old and had a son. At the bottom, this case deals with the rape of a child, which occurred over 30 years ago. At this time, case was filed. Plaintiff, who is now a 50-year-old adult, had difficulty remembering her age, the exact date, and the exact location of the assault. The UMG defendants want this court to punish a child victim of rape for failing to remember the intricate details of the assault that occurred 30 years ago. New York State Appellate Division Second Department held that it is common occurrence for a SA survivor who were children whose assault occurred 20 to 30 years prior to filing not to remember the intricate details of their assaults with the uh, calendrical exactitude. This court has stated recently in the context of the CVA that we recognize that the matters of the SA involving minors, as recounted by survivors years after the fact, dates and times are sometimes approximate and incapable of calendrical exactitude. And then they state case law. The UMG defendants desperately point to the fact that Monica case did not come forward until they filed their motion to dismiss as some bogus makeshift legal maker that requires plaintiffs to have known or have learned that she was raped in New Jersey and not New York before the filing in this court. They conveniently ignored the possibility that Ms. Case and plaintiff lost contact over the last 30 years. They ignored the case attracted immense media attention, which caused the plaintiff's friends and family to reach out to her for support. This outpouring of support led Monica Case and her sister to seek out plaintiff to lend their support. At the onset of this litigation, plaintiff only had two uh, excited, utterant witnesses. It took her time to acquire her medical records, which were used to fill in some of the holes in the initial pleading. When Miss Case and her sister recently came forward, they provided plaintiff with an image from the day of her grape and gave additional context surrounding the events that took place that led to plaintiff's grape. Kirk Burroughs recently retained this writer. Mr. Burroughs provided additional context concerning where the defendants Aaron Hall and Sean Combs lived in 1990 and as he worked directly with Sean Combs in 1990. The information Mr. Burroughs provided corroborated with Miss Case and her sister shared. I chose not to include Mr. Burroughs' declaration and the declarations of the plaintiffs' three other witnesses because it would be pointless as this court does not have jurisdiction over this case. So he is now acknowledging that this court does not have jurisdiction, and we'll read on and you'll see what he pretty much tells the court he is going to do. The gravamen of this litigation is the fact that plaintiff was brutally raped by the individual defendants in 1990 when she was a minor. The rape occurred in the rape occurred in New Jersey, not New York. Therefore, New Jersey has greater public interest in this case. New York State Appellate Division First Department was held that there needs to be sufficient nexus to the injury to confer jurisdiction under CPLR 302A1. Let's see, Supreme Court correctly determined that it does not have personal jurisdiction. So it's saying that this court does not have personal jurisdiction. And what they did was they stated case law to support that. So that's case law, blase, blase, blase. Let's see. Trying to get over the case law portion of it. Okay, so here the defendants provided alcohol to children in New York. Then they left these children unsupervised with their predatory male employees. Then they facilitated the transportation of these children and their predatory employees from New York to New Jersey. The UMG defendants' predatory employees brought these children to property that was uh, procured for them by UMG defendants, and the predatory employees proceeded to SA and grape the children. So, this is why Tyrone is including UMG because at the end of the day, they oversee their artists. And I get it. When I'm drafting these, I get it. But UMG is making it so hard, stating that they have no control as to what their artists do. And that very well may be. But it has to be some type of oversight when it comes to uh, things like these. Like what party like it's just so many things that are going in my head right now. So plaintiff will immediately file in Jersey. The first file rule would typically bar the plaintiff from having parallel litigation in two jurisdictions. Still, the New Jersey Supreme Court has identified special equities to disregard the deference normally paid to the first filed action in another state. As a result, the plaintiff will immediately file in New Jersey. And let's see what else. They're stating more case law. And it's pretty much saying that New Jersey has significant state interest when it deals with issues with grape and SA, and evidenced by the SA Victims Bill of Rights. So they actually have that, and that is actually a good thing that they are filing up under this in New Jersey. Let's see here, as previously stated, plaintiff was a child who was transported across state lines and raped in state of New Jersey. Considering the rulings issued by the New Jersey Supreme Court, plaintiff will exercise her right to immediately file her rape case in New Jersey. In conclusion, the plaintiff respectfully requests for the court not maintain jurisdiction over this case and grant plaintiff's motion for discontinuance without prejudice. So that's pretty much meaning that Tyrone he filed a motion for discontinuance, meaning to withdraw this case out of the Supreme Court, but to be able to file in another court in another jurisdiction. And obviously, that is what happened. And lastly, it says the plaintiff will also explore pursuing criminal charges in New Jersey against Sean Combs and Aaron Hall. It is kind of difficult to determine the criminal charges, as I know that the statute of limitation has passed for criminal charges. But we are going to see on this case how it actually goes. Um, oh man. What the else did I now? So remember, Tyrone sent that letter. So now this is, let's see, what is her name? Miss Linsky. So this is Miss Linsky's response to this. This firm represents UMG Recording and the above caption matter. We write in response to the May 24th, 2024 letter memorandum filed by plaintiff's counsel Tyrone Blackburn, which represents yet another example of Mr. Blackburn's flagrant disregard for the rules of civil procedure and professional practices. Simply put, to the extent Mr. Blackburn's May 24th letter is intended as a reply and further support of plaintiff's cross motion for continuance, this court should disregard it because the CPLR does not allow the filings of such papers for a cross motion. As this court knows, UMGR filed a motion to dismiss on April 11, 2024. Plaintiff failed to timely respond to UMGR's motion by April 25th as required. Nonetheless, the court clerk extended Mr. Blackburn's time to respond to UMGR's motion to dismiss on May 16, 2024. Extended to May 16th. Thus, by May 16th, Mr. Blackburn should have filed an opposition to UMGR's motion to dismiss and any cross motion. Mr. Blackburn filed a cross motion on May 15th, but failed to assert any opposition to UMGR's motion to dismiss. So it's like you file a motion, then the other opposing counsel has to respond that. But he filed a cross motion, but he did not address anything in Universal Music Group's motion to dismiss. This man is just out here doing any and everything. Let's see. Um Okay. After Mr. Blackburn's filing of the cross motion, the only remaining papers permitted to be filed under the CPLR 2214B were UMGR's reply brief in support of its motion to dismiss the first amended complaint and a response to any cross motion submitted by Mr. Blackburn. UMGR's papers were due one day before the return date of May 24th. UMGR complied with that timeline and submitted its opposition to Mr. Blackburn's cross motion on May 22nd, 2024. Let's see. I'm trying to see. Moreover, the May 24th, so she's talking about his letter. So the May 24th letter is wholly improper and should not be entertained. The May 24th letter, like Mr. Blackburn's earlier letters to the court, so this ain't the first time he's been submitting letters like this, is replete with a new allegations that are wholly unsupported by both the complaint and the supplemental case affidavit. Even assuming the case affidavit it is properly before the court, which it is not. Indeed, Mr. Blackburn's May 24th letter is principally a mix of hearsay and legally baseless arguments that have nothing to save the complaint. So, pretty much, if you file a complaint and opposing counsel files a, some type of response denying everything in a complaint and files like a cross motion, and then how can I say this? You have to come back and amend your complaint to address everything that they opposed. But for some reason, he was not doing that. He was just what they are saying is hearsay and baseless arguments, meaning that he has no type of evidence or documentation or anything of that nature to support any of the claims that he is making. And then when he goes on these rants, he's just ranting about nothing. And it's crazy. At most, the May 24th letter demonstrates the ever evolving nature of plaintiff's claim and Mr. Blackburn's complete failure to conduct even a basic diligence before commencing the action. For example, in the May 24th letter, as well as in his May 15th affirmation, Mr. Blackburn states in his opening paragraph that on or about 1990, 16-year-old plaintiff was provided alcohol by defendant UMG, was transported from New York to New Jersey in a car service provided to her by defendant UMG, and brutally raped by defendants Aaron Hall and Sean Combs. Aaron Hall was an employee of defendant UMG at the time. But it, as explained, hold on, let me see, I didn't miss anything. Nope. All right, so but as explained in UMGR's opposition to plaintiff's cross motion, most of these 11th hour allegations appear nowhere in either the complaint or in Monica case affidavit. And neither Mr. Blackburn's May 15, 2024 affirmation, not his present filing suggests that he has any personal knowledge of the purported facts that he asserts. It is well stated that an affirmation must be made by a party or another person with knowledge of facts. So he did nothing or provided anything to back up this claim that he made, this allegation. So is it true or not? We don't know. We don't know what this man has submitted. In short, Mr. Blackburn's May 24th letter is yet another, listen to this, is yet another improper practice that this court should not allow. He continues to waste this court's time and resources, and his continual improper practices create unfair burden and expenses for UMGR, who must continually respond to Mr. Blackburn's unprofessional behavior and misapplication of elementary legal concepts. Moreover, Mr. Blackburn continues his crusade with waste judicial resources and bring meritless cases with his declaration to immediately bring suit in New Jersey. As UMGR explained in its motion to dismiss in opposition to Mr. Blackburn's cross motion, the claims against UMG are meritless, and any claims brought in New Jersey against UMGR necessitate the application of New York's statute of limitations and accordingly would be time barred and also would be subject to dismissal on the merits as well. This court should disregard the May 24th letter and grant UMGR's motion to dismiss in its entirety. So the Supreme Court did not dismiss this, and this is their decision. I'm not going to read it because it's pretty lengthy, and you're more than happy to go on there and read that. I should start posting the links to these. But as you can see, they ended up granting the discontinuance and allowing him to file in a New Jersey court, which is a good thing. Um, the way that he is doing things, like I said before, it's kind of scary because you still have to make sure that you take your client into consideration. Because if you would have messed this up for her, um, just think of how she would have felt. She didn't put in all this work, all these people that are coming and supporting her, things of that nature, only to get her case dismissed, and possibly the not the opportunity, but possibly being denied ever even filing against Sean Combs again. Tyrone got to do better. So here's the case that is now in New Jersey. It was filed on June the 6th, and that's all that we have. We don't have any other information. It doesn't show that let me see if the summons has gone out. No, that's just the complaint, the case information sheet. I don't even see that. Let me just select all. I don't even see that a summons was even issued. This is just the complaint. Mm. It's interesting. It's just like, how would these people get um these pictures with them in it? I think I might do a members live and we go through these petitions, because I want to do one for each night. I might have to break them up in series. Oh, there go the summons. But I don't see that the summons was issued just yet. So, no. So the summons was included. They just have not issued the summons yet. So all of this is Miss Lisa Gardner. I'm about to say Garza. Miss Liza or Liza Gardner. I think that's how you say her name. All right. So, that's that case. Now going, and I haven't even got through the timeline. So then we have a Jane Doe, and she filed her case on December 6, 2023. Uh, Diddy was not served. But also Daddy's House Recording and Bad Boys Entertainment was also a defendant in that case. And they ended up being served. They filed their notice of appearance and they submitted a motion to dismiss. And once again, they are fighting the statute, saying that, this happened so many years ago, blase, blase, blase. And then, the norm of they, made an allegation in the complaint, but they didn't back it up. The usual. And then lastly, just pretty much the actions of the past do not fall under certain acts that are in place now. So it's just crazy how they are. And I get it, as a defense attorney, you want to find a loophole to dismiss this case. But looking on the victim's side, it is crazy that you are filing these cases and you don't really have that, what should I call it? You don't have that confidence that your case is going to make it, because you're going against all of these big wigs, especially the ones who have money, and they're not doing anything about it. And of course, Diddy is not going to respond. On this one, I don't even think, I know a summons went out, but I don't think he responded. And I don't know if Daddy's House Recordings and Bad Boy Entertainment, if that attorney is also covering Sean. So we don't know at this point. But the last thing that is going on is they are trying to fight for this case not to be dismissed. So that's what's going on with Jane Doe. Jane Doe filed her case on December 6, 2023. Then we come to Rodney Jones, and I've went over that on another platform. So that is in my playlist if you do want to go over and watch that. But there's a lot of back and forth going on. It is the same thing in each of these cases, but I'm gonna get back to Rodney Jones. So Rodney filed his February 26, 2024. Then you have Crystal McKinney, who filed hers on May 21st, 2024. And summons have been issued to Bad Boys and Universal Music Group, but once again, Sean has not been served. Mr. P. Diddy has not been served. Same thing with April Lampos case. Her case was filed on May 2nd, 2024. But unfortunately, Sean has summons has not been issued, if I'm not mistaken, for that. And if it has, he hasn't filed an answer or responded to that. So this man actively has one, two, three, four, five, six civil cases that is going on right now. And then on top of that, you got the feds. The you got the feds, Homeland Security, and that process is going to take time, especially when they have a lot of evidence to go through. And then from all these civil cases, whatever comes out as far as the evidence, that can be used in their investigation. And that's the cool thing about that. But they still have to do their due diligence, and they have to go through whatever evidence they collected. I'm pretty sure that they're setting up interviews with certain people that were around him, near him, working for him, friends with him, victims of him, whatever the case may be. It takes time. These federal cases takes time. Now, knowing that they are involved, that's one thing. But when Homeland Security has to step in, same situation with R. Kelly. Homeland Security stepped in too. A lot of people don't know that, but that's what happened. Okay. Um. So I'm going to kind of jump to, let's see, Combs case. And the biggest thing is Tyrone Blackburn. So we seen in Miss Gardner's case of Tyrone just putting allegations out there with no proof, no substantial proof. You have pictures, that's all great and all, but when you put allegations out there of rape and essaying and stuff like that, do you have that evidence? Because if you don't, that is why these attorneys on these cases are getting pissed off, because this man is sitting there making all of these allegations. And you can paint a vivid picture in your mind as to what happened as if you are there, because that is how detailed he is making these complaints. Even the letters that he is submitting to the court to back up whatever it is he's supposed to be supporting, he is still giving us these colorful language and text within these documents. So, once again, like in everybody else's case, they are trying to move to get these cases dismissed. But on top of that, and I spoke about this, I believe, in another update with Diddy, that he had motions for sanctions filed against him. That is a penalty. And it's not just for, well, the way that I explained it last time was that, if you are in the discovery phase and opposing counsel is asking for certain documents and you don't turn those documents in over and over and over again, they're sending out this request and you're, constantly ignoring them, they could file sanctions or a penalty on you. So this is pretty much what is happening. They are asking, like, first of all, you are naming all of us in these lawsuits, but you didn't do your due diligence to find proof to show that we are connected somehow, some way. You're making all of these allegations, but yet you are not providing documentation, showing that it's a connection between us and Diddy. They're not saying that he didn't do it. What they're saying is they don't have any type of liability or connection with what he does. So they're not denying it. They're just saying you're naming us for what? How are you connecting us to him besides, we gave him money to produce this record or so on and so forth. So that is the biggest issue that they are fighting right now. So this is Tyrone's response to Universal Music Group trying to get out of this. Like, one, they're trying to get out of this, but two, I'm going to sanction you because you're just putting out all this false stuff out here with no type of supporting documentation. So really it is crazy, and I have to pull the transcripts, and I think I might do that in members so we can kind of dissect this. But the court transcripts, the phone calls are hilarious. So not only is it these letters that are being filed in a court docket, but it's also the transcripts of them having telephonic hearings. And a judge, if I was the judge, I would be like, "Oh my gosh, this is diabolical. What are y'all doing?" But anywho's, all right. So let me see. All right, so this is a declaration. So a declaration is pretty much like you are under oath and you're telling nothing but the truth. Okay. That's what it is. Just like when you get a document notarized and the notary is supposed to say, is all the contents of this document true, so on and so forth. So this is Tyrone's declaration. So he's over 18. He's thoroughly familiar with the matters, and this is what he set forth. So what he's saying is that UMG's motion to sanction him should be denied, and this is the reason why. It says UMG defendants authored the dismissal documents and are using their work to justify sanctions under the court's inherent power. So on May 10th, 2024, I'm speaking from Tyrone, okay? I emailed Donald Zakarin, counsel for the UMG defendants, to inform him of the plaintiff's decision to dismiss the case against them. I sent Zakarin my proposed notice of voluntary dismissal. Zakarin insisted on drafting a completely different notice of voluntary dismissal and declaration. So I'm assuming that they possibly worked out something to where he said, "Okay, I am going to voluntarily dismiss UMG from this if y'all do something else." And possibly Zachary did not agree with that. Thus, the reason why they filed their own notice of voluntary dismissal and declaration. He said, "I filed the document prepared by Zakarin as an extension of good faith." So he did it, said, "Hey, all right, I'm going to use yours and I'm going to file this." Prior to the plaintiff's decision to voluntarily dismiss his claims against the UMG defendants, we spent extensive time researching and investigating the validity of Sean Combs' signature on the agreement between Love Records, Combs, and Motown. We pulled over 40 examples of Combs' signature from agreements he signed with various artists, record labels, and banks for mortgages. Many of these signatures came from the exhibits from prior litigation Combs was involved in throughout the years. We even secured the services of a handwriting expert who confirmed our suspicions that Combs did not sign the agreement with Motown. As a result, Plaintiff Jones felt that Motown and UMG defendants were more likely the victims of fraud perpetrated by Combs, and it would be implausible to hold them equally liable for the harm Combs visited upon Mr. Jones. So what this is pretty much saying is that after Tyrone filed this petition, he shouldn't have included Motown or UMG because Combs allegedly, or somebody did some fraud. So whatever agreement there is between Motown and UMG and Combs is really not an agreement because the signatures was forged on it. That's what he's alleging. Okay. But he did his due diligence and hired a handwritten service to kind of look at these signatures and see exactly if they were really the signatures from these groups. Interesting. On or about April 26, 2024, before the discovery that Combs did not sign the Motown Love Records contract and subsequent decision to voluntarily dismiss the case against the UMG defendants, plaintiff received a Rule 11 motion. So what he's saying is that he was going to agree, and when I say he, Tyrone Blackburn was going to agree to remove Motown and the UMG from the court case. He was going to drop them voluntarily. But before he did that, opposing counsel filed a Rule 11, which is a motion for sanctions. So I'm pretty sure they're not just watching this case. Well, obviously they're watching this case because they're the attorneys for the defendants, but they are watching other cases that Tyrone is on and they're noticing a pattern. So they filed sanctions. The email in Exhibit 5 states explicitly that the plaintiff has until May 17th to voluntarily dismiss the case against the UMG defendant, or the motion for sanctions will be filed. In reliance on the April 26, 2024 email and extension of good faith, I agree to allow Zacharian to amend the dismissal documents in exchange for the defendants not filing the sanctions motion on May 17th. So Blackburn wanted Zakarian to amend dismissal documents. I'm pretty sure that there was certain language he either wanted added or taken out. And he said, okay, they said, wait, let me see. I agreed to allow. Yes. So how can I explain this? Sometimes if we want something done by the opposing counsel, we would draft the documents on their behalf. Okay. So this is just saying that Zacharian, so even though Tyrone was going to voluntarily dismiss the case, Zacharian was actually drafting up the documents on behalf of Tyrone to do that. But it was certain things in there that Tyrone did not like. And he said, okay, um, I'll go ahead and agree to some of these things, include that in the dismissal docket. And they'll be like, okay, so we'll do that and we won't file the sanctions. All right. So they came to some type of agreement, but unfortunately, I don't know. Like I said, I guess they got tired of dude and they just said, F it, and we're going to file sanctions on dude. The documents were filed. Zacharian consented to following up filing, and the court dismissed the UMG defendants from the case. So they actually got dismissed from the case. On May 17th, 4 days later after the dismissal, Zacharian double crossed this writer and filed a revamped version of the Rule 11 sections motion. There's beef going on. Zachary used unethical gamemanship to get plaintiff to voluntarily dismiss his complaint against the UMG defendants with prejudice. And that means anytime if it says with prejudice, that means that they can not file ever again against them. Ever. In exchange for not filing their sanctions motion, Zachary disguised this Rule 11 motion for sanctions as a sanctions under 28 USC Code, I'm sorry, USC Section 1927, and the court's inherent powers. A close look at both documents will allow the court to see the motions are nearly identical. Zachary did not have the decency to attempt to hide his bad faith. Instead, the motion, according to 28 USC 1927 and the court's inherent powers, it's replete with Rule 11 sanctions case citations. I honestly should have known better than to believe Mr. Zachary would act with integrity. His actions at failed gamemanship during the April 9th, 2024 hearing was a clear indication of truly or of who he truly is. Y'all, I have to pull that transcript because that ish is hilarious. Not only was Zachary unprepared during the April 9th, 2024 hearing, as it was evident that he had no answers concerning the apparent inconsistencies displayed in the Motown, Combs, and Love record contract, but he also tried and failed to convince the court that the plaintiff should not be permitted to file his second amended complaint. And that was the biggest thing there, because remember they had the first complaint that listed some of the defendants, then it and including Stevie J. Remember that there was a photo in there with allegedly Stevie J performing an act. And then the second amended complaint came around. They totally took that out of there because one, they even found out that wasn't even him. That was another adult entertainer. So Tyrone is just putting all this stuff in there without even doing his due diligence to ensure that the information is, true and correct. It says, as the court indicated, the plaintiff's second amended complaint complied with requirements according to the Rule 11 because it corrected the objections raised by the defendants in their letter on March 4th. The plaintiff's decision to amend rather than voluntary dismiss infiltrated Zachary, but the defendants' refusal to back down and vet the new information they provided and support their position, the Motown, Love Records, Combs contract, does not amount to bad faith or to the conclusion that the plaintiff knowingly filed false statements or multiple figureless arguments. So pretty much what he's saying, and I know that this is long, he is just saying that UMG, they acted in bad faith. They acted in bad faith. And I will probably post the link to this so you guys can read this for yourself. He is just really trying to say that everything that he has stated in his complaint, in that second amended complaint, is true. Everything that he stated is true. So he said, plaintiff provided details about individual players in Combs RICO and trafficking enterprise. One of the visuals they highlighted was Brendan Paul. So UMG is trying to say everything in the amended complaint is not true. Tyrone is saying everything is true because look at what happened. What happens with Brendan Paul? He got caught at the airport with whatchamacallit, with drugs. Mm-hmm. He transported cocaine, Tootsie, and other illegal drugs, sharing that he would transport it through his carry-on luggage through TSA. The plaintiff, and in that complaint, what did Tyrone do? He actually put screenshots of the video showing Mr. Paul with the drug pouches, showing off the bottles of illegal drugs. And what happened? He was arrested at Miami airport for that. Mm-hmm. The second complaint, also, Mr. Jones, the plaintiff, provided details of the trafficking. He included a chart with phone numbers and dates and Uber receipts of 8 Lady of the Nights. March 25th, let's see, Southern District of New York and the United States, um, Department of the Homeland Security raided two of his houses and his private jet. The raid was part of the trafficking investigation. So, pretty much what he's trying to say is everything that y'all are saying in that complaint, y'all are saying is not the truth, but yet look at all the events that are happening. Look at everything that is unfolding. Look at everything that is unfolding. Mm. Let me see. UMG defendants had knowledge of Combs' checkered past. So this is Tyrone saying, even though y'all got dismissed from the case, this is how I am connecting y'all to Diddy. Before November 16th, 2023, that is the date that Cassie filed her lawsuit, defendants were willing to crawl over hot coals to touch the hem of Combs' garment. They was defending that man to the moon and back. They did not care that Combs pow powed how you say her name? Natania Griffin in the face in a nightclub at 1999. They did not care that Combs beat up one of his executives, Steve Stout, with a bottle of champagne. They did not care that Combs assaulted his son, Justin Combs, college football coach at UCLA in 2015, with a kettlebell. They did not care Combs was accused in 2019 of stomping a baby out of the stomach of his ex girlfriend, Gina Huen, and forcing her to have multiple against her will. None of Combs' deplorable public acts mattered to UMG. They were willing to look past it all and marry themselves to Combs because Combs was potentially good for UMG's bottom line. They gave this man $1.3 billion, not billion, but million. It says to distance themselves from Combs. It says that UMG defendants produced a heavily redacted, self-serving document purporting to be a distribution contracts with Combs. That's crazy. It's redacted like that. This sham contract did nothing to free them of their questionable self-serving decision to partner with him. If the contract is real, as the UMG defendants gave Combs over $1.3 million of free money for work on an album that was never done. In addition to giving him free money, the UMG defendants did not bother to ensure that Combs adhered to any of the provisions in the sham contract. I want to know what this contract looks like. For example, Section 4.04 required Combs to get pre approval before hiring any producers, and the producers were required to sign a contract approved by Motown. The final and probably most troubling revelation of Combs and UMG defendants' sham agreement is that Combs did not sign the agreement. So you gave this man $1.3 million, but not once did he sign this agreement. The point was raised to Zacharin. Blackburn asked Zacharin to provide the certification page from DocuSign so we can confirm Combs' location on the date of the signature. The DocuSign document has an IP address that can determine where it was sent from, where the person who opened it was located, and where the person who reviewed and signed it was located. It was a simple ask that anyone with integrity would be willing to share. True to form, Zacharin inexplicably denied the request, even though he presented the sham contract to the. So you presented a contract to the court that wasn't signed, nor did it have the certification page that's on it. Everybody knows, like, when you electronically sign, there is a page that is attached to the end that shows when you received it, what time you signed it, what time it was sent, so on and so forth. So, yes, this is interesting. And he's going on to say that they're trying to paint him in a bad light. And this is Blackburn. This is Blackburn. So he's attempting to distract from the fact that he has no basis to file the sanctions. So he's really trying to explain himself to the court that this motion for sanctions against him should be dismissed. Why? Because not because he has provided evidence to support, but because everything that he has stated in that amended complaint has came true. The drug mule, the contract between Diddy, UMG giving him $1.3 million, and all of that stuff, and the fact that they have overlooked so many things that has happened in in Diddy's life while he was up under Universal Music Group. So this Tyrone, I don't I don't know. I'm very curious as to what the grievance committee is going to say about this. Um I think that's all I gotta say on that. Let's see. Stop sharing. Yeah, I'm very curious as to what the grievance committee is going to say about, the things that Tyrone is putting in the atmosphere. I get what he's saying. I know that when you are drafting these petitions that you want to bring a vivid picture to not only the defendant but to the court when it comes to certain allegations. Now, for me personally, when I draft petitions, it's based off of factual information, things that I am able to look at and confirm. So, like if I'm drafting a car wreck complaint, and I'm entering the facts. I'm looking at the facts based off of not only what the plaintiff has told me, but what the officer witnessed when he arrived on the scene. And that's why I use the crash report. So for Tyrone, you're putting all these allegations, just like with the Stevie J situation, and you're saying this is what happened. Now, it very well may have been that Diddy promised Jones, to meet Stevie J, but why add all that other stuff and not confirm first? It's like you add all the stuff in there first and then you worry about dealing with the consequences later. No, you have too many cases in New York, in New Jersey, and not just these particular cases dealing with essaying, like any type of case. And I haven't looked at any other work that he has provided, but I am sure that they are all consistent when it comes to drafting these complaints and filing them in these courts. A lot of his cases are in Supreme Court and federal courts. And in my personal opinion, I think it is for fame. He's trying to shoot up there and be this big time lawyer. But at the same time, quality is better than quantity. Like I get it. You want all these cases, but you are putting each and every plaintiff in jeopardy when you're filing these and I can't call them frivolous because not all of them, like the allegations can be true and prove to um a certain limit, but dude, what are you doing? Um, but I am going to try to find that grievance letter. But I wanted to kind of point out to you guys what these attorneys have been writing about Tyrone. They are really tired of Tyrone. They are tired of this man, like putting out all of these lies and don't have no proof He probably, like, I want to say 85% is probably true, and then the other 15% he just makes up based off of it's going to come out. Whatever's done in the dark is going to come out. It is crazy. But yeah, so that's just a little Diddy update for you guys. It's not really too much movement right now. Normally what's going on is that these defendants are trying to fight tooth and nail to get these cases dismissed, saying that it doesn't fall under a certain act, or the statute of limitations have been up years ago. But I'm definitely going to keep you guys updated with any new Diddy court information. And that's the purpose of this channel, is going over court dockets, not providing you guys updates about their daily life or anything. But I like to look at the legal world and seeing what's happening with that, and I come back and report all of this to you guys. But definitely stay tuned. I am going to do, like I said in the beginning, like a little mini series. I don't know what I'm going to call it, but possibly Surviving Hollywood. And it's dealing with, and I'm going to do that for the whole month of July, but it's really dealing with a lot of these cases that have been filed by plaintiffs that were SA'd as early as 13 years old. Cases with Donald Trump and Epstein, Cuba Gooding Jr., Russell, what's that man's name? Russell Brand, Bill Cosby, Jamie Foxx, Axl Rose from Guns N' Roses. So I do want to do a little part series for you guys to actually enjoy, go over some complaints, and just kind of dissect and see where these cases might go in the future. But like always, thank you guys for tuning in. If you have any questions or suggestions about anything, definitely hit me in the comment section. Otherwise, I hope you all have a blessed night, productive rest of the week, and until then, be blessed. I'm out.